Good afternoon, Mr. Wood.
Good afternoon, Judge.
Good afternoon, Mr. Bruner. How are you, sir?
Okay, man.
All right, this is cause numbers CR 2042 and CR 2041. State versus J. Michael Bruner. It's my understanding that Mr. Bruner wants to enter into a plea agreement with the state today in cause number 41 with a dismissal in 42. Is that correct, Mr. Wood?
That's correct, Your Honor.
It looks like he's going to be pleading guilty to a third-degree felony offense of unlawful possession of a firearm by a felon. In exchange for that, the state's recommending punishment at 2 years TDC, dismissing several other charges: assault, cause of bodily injury, assault against public servant, resisting arrest. There's also a weapon forfeiture as part of this agreement. And Mr. Bruner would receive 496 days credit towards his sentence in this plea agreement. Is that right, Mr. Wood?
That's correct, Your Honor.
Mr. Bruner, is that your understanding of what's happening today?
Yes, sir.
All right. Mr. Bruner, I'm going to ask you to raise your right hand so I can place you under oath. There you go. Mr. Bruner, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right. You can put your hand down. Mr. Bruner, I've got a few questions for you. Are you a United States citizen?
I believe so.
Do you read, write, and speak English?
Yeah.
And have you ever been diagnosed with any type of mental condition?
No.
Mr. Wood, do you know if Mr. Bruner has any official diagnosed mental disorders?
Judge, I don't believe it's anything official per se. I know Mr. Bruner has been evaluated a couple different times by two separate psychologists who both deemed him to be competent to stand trial. And I take their expert opinion as to the fact that he is competent. I've been able to communicate with him regarding this recommendation of this plea and what's happening today. He understands what's happening today, and he's willing and wanting to move forward on the case.
Thank you, Mr. Wood. And Mr. Bruner, do you feel like you've had enough time to discuss your cases with Mr. Wood and have all your questions answered?
Yes, sir.
Been in jail a long time, and you and Mr. Wood have met several times, and you feel like you understand everything that you've read and signed today in this plea agreement. Is that right? Can you have to say it? Yes. Unfortunately, you have to say out loud yes or no. So my court reporter can type down what you're saying. All right. So Mr. Bruner, I have to give you a little more information. You are charged by indictment with an unlawful possession of firearm by a felon. That does carry a range of punishment. If convicted and sentenced, your sentence must be somewhere between the minimum of 2 years confinement in TDC to the maximum 10 years confinement and a fine of not more than $10,000. That's the full range of punishment, and the plea agreement that you would be entering into with the state today would be for the very minimum in this case, and that would be the minimum of 2 years. So understanding that, Mr. Bruner, at this time I'm going to ask you, how do you plead to unlawful possession of firearm by felon? Are you guilty or not guilty?
Guilty.
And Mr. Bruner, are you pleading guilty because you are guilty of committing that crime?
Yes.
And Mr. Bruner, has anyone threatened, forced, or pressured you to plead guilty in court today?
No.
All right, court accepts the defendant's plea of guilt. Mr. Wood, any objection to the state's evidence?
No objection.
All right, state's evidence is admitted, and the court does take judicial notice of Mr. Bruner's judicial confession. Anything further from the state?
No, Your Honor. At this time, we'd rest and close.
Anything further from the defense?
Nothing further, Your Honor.
Take just a brief second or moment here to look over the evidence. All right, the court's reviewed the evidence. I do find enough evidence to convict Mr. Bruner of this offense. The court will follow the plea agreement. The court hereby convicts J. Michael Bruner of unlawful possession of firearm by a felon. Court assesses his punishment pursuant to the plea agreement at 2 years confinement in the Texas Department of Criminal Justice Institutional Division. The court orders him to pay a zero fine, $290 court cost, $85 in reimbursement fees. The court awards Mr. Bruner 496 days credit towards his sentence. The court takes into consideration under Section 1245 of the Texas Penal Code, cause numbers 20-20-74, which is an assault causes bodily injury, M19-946, which is an resisting arrest, CR 2042, aggravated assault against a public servant, and 2021-98, resisting arrest, into consideration and dismisses those under Section 1245. The court also orders the forfeiture of a weapon, namely a black 9mm Ruger LC 9S serial number as indicated in the judgment. And state with regards to dismissing the other offenses that contain allegations of violence, are those victims been notified? Are you in compliance with victim notification on those dismissals?
Judge, I believe the state is in compliance. I don't believe we received anything back, but we sent notification.
All right. Thank you. All right, Mr. Bruner, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. I'm going to have you step over with my deputy to be fingerprinted. After that time, good luck to you, sir.
Judge, I believe that's all I have for this afternoon.
Mr. Wood, I believe this is maybe the ending of an era with you. And so I want to thank you for your service to Van Zandt County. I want to thank you for your professionalism and your zealous advocacy of Mr. Bruner throughout this time. I'm still indebted to you, I know. Thank you, sir.
Thank you, Judge. See you soon.
Very soon. Oh. Mr. Weiner, are you ready?
Yes, I'm Kelsey Tippy, Judge.
Mr. Tippy, if you'll come forward, please, sir. Bearings here. All right, Mr. Weiner, walk me through this. Looks like we're going to be pleading to CR 18-143 and CR 18-144 as to count one. And so let me see here. What about CR 26-6? Is that going to be a 12? Yes, that's going to be. It's going to be a 1245. That's CR 18-143. Okay. And so in the one that's alleging count one, was that a multi-count indictment or was that? Assuming that was a multi-count indictment.
Your Honor, it was, and the state just elected to proceed on count one.
All right, Mr. Tippy, if you will, sir, raise your right hand so I can place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir. Nothing but the truth.
All right, you can put your hand down. Your name is Kelsey Tippy, is that correct?
Yes, sir.
Mr. Tippy, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No.
In this case, you're represented by your attorney, Mr. Justin Weiner. Are you pleased with his representation of you?
Yes, sir.
Feel like you've had enough time to discuss these cases with him, have all your legal questions answered?
Yes, sir.
there anything about the paperwork that you've read and signed today with Mr. Bruner that you do not understand?
No, sir.
Why do you believe your client to be competent today?
New Judge.
And it looks like the plea agreement is that he's going to be pleading guilty on, let's see, CR 18143, the registration offense. Upon a plea of guilt, state's recommending 8 years confinement and TDC, $2,500 fine, 1245 for bail jumping, failure to appear, court costs, reimbursement fees, 1,233 days credit towards the sentence in that cause. And looks like a very similar recommendation on the possession case 144, with the state abandoning the other counts, fine, reimbursement fees, the same credit time. Is that your understanding of the plea agreement, Mr. Weiner?
It is, Judge.
Okay. All right, Mr. Tippy, in cause number CR 18143, you were indicted with the second-degree felony offense of sex offenders duty to register for life 90-day. A second-degree felony carries a range of punishment of not less than 2 years or more than 20 years confinement in the Texas Department of Criminal Justice, and a fine not to exceed $10,000 and/or a fine. And in CR 18144, you've been indicted with the third-degree felony offense of possession of child pornography, which carries a range of punishment of not less than 2 years or more than 10 years, and also an optional fine not to exceed $10,000 as well. Do you understand the range of punishment in each one of your cases?
Yes, sir.
All right, so at this time, Mr. Tippy, I'm going to ask you, how do you plead to the second-degree felony offense of sex offenders duty to register for life?
Guilty.
And how do you plead to possession of child pornography?
Guilty.
Mr. Tippy, are you pleading guilty to each one of those crimes because you did in fact commit each one of those crimes?
Yes, sir.
So Tippy, has anybody or anyone threatened or pressured you to make you feel like you had to plead guilty to either of these charges?
No.
All right, the court will accept the defendant's plea of guilt at this time. Mr. Weiner, any objection to the state's evidence?
No, Your Honor, we've received the state's offer in both cases and no objection.
All right, state's evidence is admitted in each case respectively, and the court takes judicial notice of Mr. Tippy's judicial confession. Is there anything further from the state?
No, Your Honor.
From the defense, Mr. Weiner?
No, Your Honor.
All right, give me just a brief moment to review the evidence. All right, the court has reviewed the evidence. The court does find that there is sufficient evidence to convict Mr. Tippy of each of these offenses. The court will follow the plea agreement that Mr. Tippy has reached with the state. The court hereby convicts Kelsey Tippy of sex offender's duty to register for life, second-degree felony, assesses his punishment in accordance with the plea agreement at 8 years confinement in the Texas Department of Criminal Justice, $2,500 fine, $290 court cost, $120 reimbursement fees. Court will take into consideration under section 1245, cause number CR 266, a bail jumping pure felony. Court awards Mr. Tippy 1,233 days credit towards his sentence in that cause. With regards to CR 18144, count 1, court finds that there is sufficient evidence to convict Mr. Tippy and does convict him pursuant to the plea agreement. of a third-degree felony offense, possession of child pornography, assesses his punishment under count 1 at 8 years confinement. The Texas Department of Criminal Justice Institution Division court orders him to pay court costs in that matter of $290 and reimbursement fees of $140. The court finds that the state has abandoned all other counts remaining in the indictment. The court will order the sentence in each case to run concurrently with the other sentence imposed today. The court also awards Mr. Tippy 1,233 days credit towards his sentence on CR 18-1. Mr. Tippy, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence. And I want to ensure that Mr. Tippy has been provided with a copy of Chapter 62 of the Texas Code of Criminal Procedure regarding the sex offender program.
He has, Judge, and I'm glad you mentioned I was going to if we didn't. But he was already registering for life already. But I gave him a whole copy of Chapter 62. It was furnished by the DA's office. He understands his obligations.
Thank you, Mr. Weiner. All right, Mr. Tippy, I'm going to have you step over with the deputy to be fingerprinted. Good luck to you, sir.
And that's all I have, Judge. May I be excused?
Yes, thank you, Mr. Weiner. Good to see you.
Good afternoon.
How are you, sir? It's like you just have one on today's docket, Donald Patterson, is that right? All right, this is Coffin PR 351. And this, I believe, is your motion for bail reduction, Mr. Stevens, is that correct?
That is correct, Your Honor. Also, except for pre-trial, but I've got a video, but I don't have the paper discovery, probably because I replaced Miss Beasley and I probably hadn't been hooked into the computer yet.
Judge, I will work on that while Ms. Heisel does the bond hearing. We'll make sure that Mr. Stevens has that right now.
Okay, so what I'll do, Mr. Stevens, is I will go ahead and set this for docket call, and then I'll grant leave for filing of a late motion if you get that video and believe that there's an issue that needs to come be heard, okay?
Okay, thank you, Judge.
All right, so just go ahead and look at your calendar. Are you available April 12th or 14th?
April 12th, Your Honor, I'm here in your court anyway that afternoon.
Okay, we'll set Mr. Patterson then for docket call on April 12th. And are you going to call your client today for purposes of bail reduction?
Yes, sir.
Mr. Patterson, sir, raise your right hand so I can place you under oath. Mr. Patterson, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, you may put your hand down. Just make sure you speak up loudly and clearly for me, okay?
You said,
Go ahead, Mr. Stevens.
Thank you, Your Honor. Please state your name for the record.
my name's Donald Cameron Patterson.
Mr. Patterson, how long have you been in this?
2 months originally, and then another 2 months now, so I think almost 5 months altogether.
The bond is currently set at $5,000, which you obviously have not been able to post that bond, correct?
That's correct.
What was your original bond set at?
Original bond was 10.
10,000, and you actually made that bond, but then you fell into some financial hard times around Christmas, lost your dad and financial difficulties. So as a result, your bond's off the bond. Is that correct?
That's correct, yes, sir.
Okay. Now, do you have any cash that you could apply toward this bond?
I did not.
Do you own any property to sell bond or mortgage to put toward the bond?
No, sir, not at this point.
Okay. If you were to be able, if the judge reduced the bond, if you were to be able to get out, do you have work lined up?
Yes.
Okay. What kind of work do you do?
I'm a crew foreman for a landscape company, drive a truck there.
Okay. And is it a job that will be there if you're able to get out?
Yeah, it's supposed to start March 1st.
Okay. And who's going to help post the bond?
My sister works for Dell down in Austin, and I've got strong family support, and they want to help.
Okay. So they'd be the ones helping post the bond.
Yes, sir.
And how about your living condition? Where are you going to live?
So I've got a transitional house that I want to with in connection with my church. That's a sober with accountability for church and things like that.
Okay. Where is that?
It's located in North Dallas, Court 635 area.
Okay, and is that where you'll be living if you're out on bond in this court settings?
Yeah, right there at the edge of Dallas and Richardson.
Okay.
Churches in Addison and. So,
Okay. Do you have transportation to get to and from the courthouse?
yes,
Okay. We would provide that transportation.
the truck that I'm driving for work, the boss is aware of everything that's going on and he's in support of helping me whenever we can. So I'll be able to drive the company vehicle to back forth to probation or court or whatever it needs to do.
Okay. Are you asking the judge to reduce the bond to $5,000?
That would be fantastic.
Is that an amount that you think your sister would be able to help post?
I hope so. But yeah, it'd be a lot better than 25, yes, sir.
Okay, and can you promise this court you'll make each and every one?
Without a doubt.
Ask the witness, Your Honor.
State, any questions?
Just briefly, Your Honor. Mr. Patterson, do you understand the charges against you in this current cause?
Yes, ma'am.
Do you understand that this cause involves violence? I'm sorry, Judge, I'm getting feedback. Can everybody else hear me okay?
Now we can.
Mr. Patterson, are you aware the allegations are involving violence to a gentleman who was over the age of 65?
Yes, ma'am.
Mr.
Yes,
Patterson,
ma'am.
this isn't your first offense involving violence, is it?
I haven't really been violent. Or anything. There's been a robbery. There's been an assault went back, but they weren't violent things, if you will.
Your Honor, I pass the witness.
Mr. Stevens, any further questions?
No further questions.
All right, do you want a closing argument, Mr. Stevens?
Judge, you've heard the testify. He has a family out there. He's got a sober living place he's going to go reside in. He has a job lined up. He has transportation to get to and from the courthouse. And we would respectfully, Your Honor, ask you to reduce the bond to $5,000.
Tyson.
Your Honor, the state is going to ask you to take judicial notice of the file, including the indictment in this cause. We do not believe Mr. Patterson is entitled to a bond reduction. Furthermore, this is a violent offense with some previous history of violent offenses. And because of that, the state has concerns that if a bond were lowered beyond what it's already been lowered to, what's already been before the court, that the safety of the community and specifically the safety of this victim could not be assured in the event that the court does grant a bond of any kind. We would ask for bond conditions with no contact with the victim of this current offense.
Mr. Stevens, remind me, I think his testimony is that he was originally given a $10,000 bail and he posted bond on that $10,000 and then he failed to keep up the agreement with the bondsman and that resulted in him being arrested on a surrender. Is that correct?
That is correct, Your Honor. I would like to point out that his failure to keep up with his financial obligation resulted in work problems around Christmas time and the fact that his daddy passed away and he had family obligations that he had to attend to regarding to that. So, but other than that is correct, Your Honor. Yes, sir.
Can you or he elaborate on what those issues were that caused him to not make his payments to his bondsman?
Just financial issues, Your Honor. He had to help with the death of his dad, help cover some expenses there. His work was real slow during that period. It just was at Christmas time, it was just financial hardship on the judges. Basically what happened.
That's correct.
Okay. Anything further?
No, Your Honor.
Okay. All right. The court will take the argument under advisement and I'll issue a ruling at the end of the day.
Thank you, Your Honor. That's all I have. I'll be excused.
Yes, and Mr. Patterson, if you make bond in this case, then your hearings will be in the courthouse in the mornings. If you don't make bond, then your hearings will be on Zoom in jail, okay? In the afternoons.
Okay, thank you so much.
You're welcome. Good afternoon, Ms. Rogan. All right, is this Mr. McKnight?
Yes.
All right, this is cause number CR 17206, State versus Richard Wayne McKnight. And I believe that Mr. McKnight is already on the court's jury selection docket, but that the defense has filed a motion for bail reduction. Is that correct?
Yes, Your Honor.
All right. And Mr. Bogan, do you want to call Mr. McKnight for the limited purposes of bail reduction?
Yes, Your Honor.
All right, Mr. McKnight, if you'll raise your right hand, sir, and place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God? All right, you may put your hand down. Make sure you speak up loudly and clearly. I know you're standing right next. You put your hand down. I know you're standing right next to Mr. Bogan, and you don't want to yell at him. I understand that, but I'm on this side of the computer, as is my court reporter. I've got to hear you. She's got to take it down. So speak up as loud as you can for me, okay, sir? Go ahead, Mr. Bogan.
Okay, Mr. McKnight, how long have you been in the Van Zandt County Jail?
A little over 7 months.
So you've been in jail for over 7 months?
Yes, sir.
And what is your bail currently set at?
20,000.
And have you been able to post bail in that those 7 months?
No, sir.
And your girlfriend, Charmaine, is in the lobby today, correct?
Yes, sir.
And what are her financial resources to post bail currently?
Probably like $700.
Okay, and that's not enough for a $20,000 bond, correct? And you do have pending charges in another county, correct?
Yes, sir.
And in fact, Rains County currently has a $100,000 bond set on you.
Yes, sir.
So if you were to post bail, you would have to go to Rains County before you would be released.
Yes, sir.
But that is something that you would like to do.
Yes, sir.
And you did, part of why you're in custody is you missed your last court date.
Okay.
What happened to lead you missing that court date?
The day before we were supposed to be in court, my girlfriend wrecked our car and was hospitalized. And that was our only form of transportation.
Okay. All right, I'll pass the witness.
All right, state.
Thank you, Your Honor. Mr. McKnight, I have before me a document showing that your bondsman went off your bond in July of 2017, and that you were not rearrested until September of 2018. Does that sound right to you?
Yes, ma'am.
Okay, so for over a year there, you weren't reporting or showing up to court settings or anything of that nature?
No, ma'am.
Okay. And then I also show that a period from February of 2019 to July of 2021, there was also a current a warrant out for you during that period. Does that sound correct?
Sounds correct.
Okay. Did you know that those warrants were out for your arrest at the time?
I hadn't received it, but I kind of suspected, yes, ma'am.
Okay. But you did know that all of a sudden you weren't coming to court anymore.
Exactly. I had no transportation at that time.
Your Honor, I pass the witness.
Mr. Bogan, any follow-up?
I have no further questions.
Would you like closing, Mr. Bogan?
Yes, briefly. I mean, just point out the record shows that he's been in jail for nearly 8 months, has not been able to post bail at the current amount. A reduction is not going to result in his immediate release. It would just end up resulting in him being transferred to Rains County, where he could address those charges while waiting trial on these charges. And for those reasons, we are requesting a bond reduction.
Thank you, Mr. Bogan. Ms. Heisel?
Thank you, Your Honor. Your Honor, this is a state jail felony that has been enhanced in the indictment to a second degree. Based on that and based on the fact that Mr. McKnight has shown himself to be a flight risk, there have been 2 different periods during the pendency of this case where he was absconded for over a year, knowing that he had obligations that he wasn't taking care of. We believe any further reduction would not be sufficient to ensure his future appearance. So we would ask the court to remain his bond at $20,000.
Thank you, Ms. Heisel. All right, court, after considering the evidence and argument, is going to deny the defendant's motion for bail reduction. So the court will remain, the bail will remain at $20,000.
Thank you. And just briefly, Your Honor, I believe this case is the next trial setting March 8th. I think we're far down on the trial doc. I just wanted to let the court know in the event that March 7th is the next trial setting. I'm scheduled to have surgery on March 8th. So if by some
Okay. Do you know how far down it is on this?
The last I heard from Patty, I think we were close to 20. So I don't think there's any real risk, but given that I'm definitely unavailable, I wanted to make sure the court was aware.
I appreciate that. We'll make that notation.
All right, thank you.
Thank you, Ms. Booker.
All right.
Yes, ma'am.
Yes, Your Honor. Mr. Adams is ready with his clients. He'll be-
Who are you ready on at this time, Mr. Adams?
Mr. Teague and Mr. Schultz.
All right, Billy Joe Schultz, CR 21-243, 2020-513. Mr. Schultz going to be entering a plea today.
That's correct, Your Honor.
All right, let me see here. All right, Mr. Schultz, if you'll raise your right hand, sir, I'm going to place you under oath. Sir, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right. Put your hand down. You can make sure you speak up a little bit louder for me so that I can hear you, so that my court reporter can take down what you have to say. All right, Mr. Schultz, are you a United States citizen?
Yes, sir.
Yeah, you put your hand down. You are a United States citizen. Do you read, write, speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Mitch Adams. Are you pleased with his representation of you?
Yes, I am.
Do you feel like you had enough time to discuss both cases with him and have all of your legal questions answered?
I do.
Is there anything about the paperwork that you've read and signed today with Mr. Adams' assistance that you do not understand?
No, sir.
And Mr. Adams, do you believe Mr. Schultz to be competent today?
I believe he is, Your Honor.
Have you explained to him his legal rights?
I have done so.
And you believe he understands them?
He understands them. Yes, sir.
All right, Mr. Schultz, in cause number CR 21-243, you are charged by indictment with a first-degree felony offense of manufacture or delivery of a controlled substance in penalty group 1 greater than or equal to 4 grams but less than 200 grams. If convicted and sentenced on that type of charge, the sentence would have to fall somewhere within the range of not less than 5 years or more than 99 years or life in TDCJ and an optional fine not to exceed $10,000. Do you understand the potential range of punishment on that kind of charge?
Yes, sir.
In the other case, which is a Class A misdemeanor offense of assault causes bodily injury of a family member, if you were convicted of that, the sentence would have to be between 0 days up to a maximum 365 days or 1 year confinement in the Van Zandt County Jail with a fine, an optional fine not to exceed $4,000. Do you understand that range of punishment?
Yes, sir.
I see here that you wish to enter into plea agreements on both of these cases. In the felony case, it appears that you would plead guilty in exchange for the state's recommendation that your sentence be set at 8 years confinement in TDC, with that sentence being suspended and you being placed on probation or community supervision for 8 years, along with a $2,500 fine, $290 court cost, $180 restitution, and reimbursement fees in the amount of $1,345. Is that your understanding of the plea agreement in the felony case?
Yes, sir.
Now, with regard to the misdemeanor case, you would plead guilty to that assault causes bodily injury of a family member, and your punishment would be assessed at 147 days in the county jail. You would receive credit of 147 days for a complete serve, and you would also have a fine of $100 plus court costs of $270 and reimbursement fees of $160. Is that your understanding of the plea agreement in that case?
Yes, sir.
All right, so I've informed you of the range of punishment and the plea agreement. You appear to understand both. So at this time, I want to ask you, How do you plead to manufacture or delivery of a controlled substance in penalty group 1 greater than or equal to 4 grams but less than 200 grams?
Guilty.
How do you plead to assault causes bodily injury of a family member?
Guilty.
And Mr. Schultz, are you pleading guilty because you are guilty of committing each of these crimes?
Yes, sir.
All right, court will accept the defendant's plea of guilt. Mr. Adams, any objection to the state's evidence in each cause?
No objection, Your Honor.
State's evidence is admitted in each cause respectively, and the court does take judicial notice of Mr. Schultz's judicial confession. Anything further from the state? And I need to know if the state's in compliance with victim notification.
Judge, nothing further from the state. Let me check on victim notification. Judge, we provided victim notification. It does not appear as though we received any information back from the victim of that charge.
All right. Anything further from the defense, Mr. Adams?
No, Your Honor.
All right, the court has reviewed the evidence in each case and do find sufficient evidence to convict Mr. Schultz of each offense. The court will follow the plea agreement in each case reached with the state. The court hereby convicts Billy Joel Schultz Jr. of manufacture and delivery of a controlled substance, penalty group 1 greater than or equal to 4 grams, less than 200 grams. The court assesses his sentence at 8 years confinement in TDCJ. The court suspends that sentence, places Mr. Schultz on community supervision for a period of 8 years. Orders him to pay a $2,500 fine, $180 restitution, $290 court costs, and reimbursement fees of $1,345. Court takes into consideration DA 2021-1441, which is a possession of controlled substance. Court dismisses that under section 1245. As to assault causes bodily injury, family member of the court convicts Mr. Schultz of that offense. Pursuant to the plea agreement, assesses his punishment at 147 days in the county jail. Awards him credit for 147 days for the time that he's already served in jail on that cause. Orders him to pay a $100 fine, $270 court costs, and $160 in reimbursement fees. Mr. Schultz, you hereby remanded to the custody of the Van Zandt County Community Supervision and Corrections Department so they can carry out the terms and conditions of the sentence. Have you ever been on probation before, Mr. Schultz? Say that again, it didn't come through. No? Okay. So, you've seen your conditions of community supervision, right?
Yes,
You've seen them. So you know what's required of you. And I'm sure that Mr. Adams has already instructed you that if you violate any of those, the state of Texas through their attorneys could file a motion to revoke your community supervision. They could bring you back to court and they could ask for a hearing. If they produce evidence that proves that you violate any of the terms of your community supervision, the court could revoke your community supervision and sentence you up to maximum 8 years in prison. You understand that?
Yes, sir.
All right. So what I want you to know is that as you're making decisions in your life while you're on community supervision, I've already made a decision today that your sentence is set at 8 years. If you violate and you come back, if you test positive for marijuana, if you drink 1 beer, if you don't do 1 hour community service, and the state files a motion and they bring you back, your sentence is already set at 8 years. Okay? So I think you'll keep that in your mind as you're making decisions while you're on community supervision that may put you in the best position you can be to make the right decision. All right?
Yes, sir.
All right, I'm gonna have you step over with bailiff to be fingerprinted, and then the probation officers there, they're gonna give you more information about what's next. Colin Teague, CR 21-191. All right, Mr. Teague, this is set for docket call today. Is Mr. Teague going to be entering the plea also, Mr. Adams?
Yes, Your Honor, that's correct.
Okay, good. Let's see. All right, Mr. Teague, while I'm reading this, if you'll raise your right hand, I'll place you under oath. Mr. Teague, do you swear that the testimony you give to the court today will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir.
All right, put your hand down. Your name is Colin Gary Teague, is that right?
Yes, sir.
And Mr. Teague, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No, sir.
In this case, you're represented by your attorney, Mr. Mitch Adams. Are you pleased with his representation of you?
Yes, sir.
Looks like you've had enough time to discuss the case with him and have all of your legal questions answered.
Yes, sir.
Anything about this paperwork that you've read and signed today that you do not understand?
No, sir.
Mr. Adams, do you believe Mr. Teague to be competent today?
He's competent, Your Honor.
And have you explained to him the plea agreement and his legal rights? If you believe he understands all of the same?
Yes, Your Honor, that's correct.
See that the plea agreement is that Mr. Teague would plead guilty to credit card or debit card abuse from March 13th of last year. The state would be recommending 321 days confinement in state jail. TDC, he would be given credit of those 321 days for time that he's already spent in jail on the cause. In addition, he would have a $2,500 fine, $290 court cost, and $40 reimbursement fees. Is that correct?
Yes, Your Honor, that's correct.
I have a question, and I may already know the answer, but I want to consult with both of you about that. With the fact that Mr. Teague is not going to prison, is his reimbursement fees, can they not be addressed to him since he's not actually going to prison? He served all of his time in the county jail.
What's the reimbursement? The person that you stole from us. Which I know they threw all that out. Yeah, I don't know. I have no problem.
Mr. Woodward, you know?
Judge, I do believe because he is not being sent to Texas Department of Criminal Justice, that the reimbursement fees can be included. I think that's the general policy of the court to not include them if it is a TDC. Even though he's not being sent, it is still technically a state jail sentence, and he'll probably likely just be released in absentia. I don't think he would go down, but it is still technically a state jail sentence. Because it's not a 1244. This is not my case, so I'm unaware of the details. It's not a 1244 A or B, so I believe it is still a state jail sentence. I believe it's generally we do not assess the reimbursement fees, but I believe that's up to the policy of the court.
Well, I think it's case law, but I'm just not sure what that is off the top of my head, so. All right.
I think we can, because it's not going to TDCJ, State Jail Division, but I don't know if just because he spent all of his time here as opposed to there, that the court necessarily wants to, is my legal opinion.
All right, so It would be a $2,500 fine, $290 court cost, and $40 reimbursement fees. Is that your understanding of the plea agreement, Mr. Adams?
Yes, Your Honor, that's correct.
And yours as well, Mr. Teague?
Yes, sir.
All right, Mr. Teague, you are charged with that credit card, debit card abuse, which is a state jail felony, which does have a minimum confinement of 6 months to a maximum confinement of 2 years in state jail and an optional fine not to exceed $10,000. You understand that full range of punishment?
Yes, sir.
Understanding both the plea agreement and the full range of punishment, at this time, I'm going to ask you, how do you plead to credit card or debit card abuse?
Guilty.
Are you pleading guilty to that crime because it's true that you committed that crime?
Yes, sir.
Has anyone threatened, forced, or pressured you to make you feel like you had to plead guilty?
No, sir.
The court will accept the defendant's plea of guilt at this time. Mr. Adams, any objection to the state's evidence?
No objection.
All right, state's evidence is admitted. The court does take judicial notice of the defendant's judicial confession. Anything further from the state?
No, Your Honor, we would rest and close at this time.
From the defense?
No, Your Honor, we rest.
All right, the court's reviewed the evidence. Court finds that there is sufficient evidence to convict Mr. Teague of this offense. Court also finds that no good deed goes unpunished. Isn't that right, Mr. Teague?
Yes, sir.
Yeah, so this couple let you come and stay at their house because they felt bad for you because you were homeless and you stole from them while you were there. It says a lot about you, sir. All right, Mr. Teague, we'll follow the plea agreement in this case. Court hereby convicts you of debit card or credit card abuse. Assesses your punishment at 321 days in the State Jail Division of TDC. Court will issue you credit of 321 days for time served already on this case. Orders you to pay a $2,500 fine, $290 court cost, and $40 in reimbursement. Mr. Teague, whenever you're released from the Van Zandt County Jail, I'm going to order you to report immediately within 24 hours to the Van Zandt County Courthouse so you can make arrangements to pay your fine, court cost, and reimbursement. Your failure to do that will result in the court issuing a warrant for you. Do you understand?
Yes, sir.
All right, you're hereby remanded to the custody of the Van Zandt County Sheriff so we can carry out the terms and conditions of this sentence and have you go over to the bailiff to be fingerprinted.
Appreciate it.
Mr. Adams, you ready? Anyone else?
Your Honor, Ms. Villanueva is the sole remaining case I have on the docket today, I think.
Ms. Villanueva, if you'll come forward. CR 21271, Ms. Villanueva is set for a docket call.
Yes, Your Honor, on behalf of Ms. Villanueva, the state and I still have not yet come to an agreement regarding any kind of plea offer. To that end, I expect that this will be resolved with a plea, but we don't have the details worked out yet. I'd ask the court to set us for another docket call to give me some more time to sweet talk the state.
Let's see, I will reset her to either March 8th or March 10th.
In the afternoon, Your Honor,
It'll be in the afternoon, yes.
March 10 would be best then.
10th, March 10th, okay. Court sets Teresa Villanueva for docket call March 10th. That'll be at 1:30. Deputy McLeish,
Yes, Your Honor.
is Mr. Nino in there?
He is, Your Honor.
Okay, we'll, Mr. Bolton's online and, the state was going to be requesting a reset of that, so we'll bring him up next and then I'll dispose of Mr. Bolton.
Yes, sir.
I'll go ahead and bring in Mr. Bolton.
Mr. Nino, come over to the podium, please.
Mr. Bolton, are you ready for the hearing?
Yes, Judge. How are you, sir?
I'm doing good. I can't really see you, sir.
Nah, here you go. I'm pulling over.
Okay, go ahead. Take your time.
There we go.
All right, this is cause number CR 21301, State versus Pedro Olivares Nino. And we're set for a plea today, and I believe we were set for a plea last time. Is there an announcement from the state?
Yes, Your Honor. At the last setting, an offer had been communicated to Mr. Nino and Mr. Bolton. We were not aware that they were accepting that offer and didn't have paperwork. In the meantime, we met with the victim's family in this case, and we still need to, Ms. Curry spoke with them on the phone. I believe they are setting up an in-person meeting to just follow up on some questions the family had. So we are going to ask for a reset on this to just allow us to make sure that the victim's family is fully informed of the process and where everybody is, so we can all be on the same page before we proceed with a plea.
Mr. Bolton, any opposition?
No, sir, not at all. We're ready to get things going as soon as they get their due diligence done and placate the victim's family. I don't want them getting a bunch of phone calls or newspaper articles written about them. Yeah.
How long do we want to reset?
Judge, we would ask for 30 days if the court would grant us that.
That's fine, Judge.
Mr. Bolton, are you available on April 12th or 14th?
Either one of those days should be fine, Judge.
All right, we're going to go ahead and set Mr. Nino then on April 12th for a plea. And that will be at 1:30. Mr. Bolton, I'm going to send you a message there. You don't have to address it. You can just acknowledge that you got it, okay?
Super. Thank you, sir.
All right, then we'll be adjourned in this hearing. We'll see you back on April 12th.
All right. Have a good morning or good afternoon, I guess.
You as well.
Thank you. Bye-bye.
Your Honor, Mr. Ashmore is ready with a few of his clients right now.
So. So. All right, Mr. Ashman, what do you have?
Judge, this is Mr. Elmore.
Okay, this is CR 21-355, State versus Jerry Ray Elmore. Set for pretrial. Go ahead, Mr. Ashman.
Judge, we don't believe we're going to have any contested pretrial matters. And just to refresh the court's recollection, I was actually surprised to see Mr. Elmore still in custody because he's got a health situation. We filed a PR bond because of his dialysis and issues with his foot. We just felt it better to get him some care outside the facility here. The state didn't oppose. In fact, I think they agreed. And anyhow, I'm just going to ask for a quick reset. I think I need to bring another motion to reduce the bond because I assume there's some sort of hold that I wasn't aware of. So I'll take responsibility for that. But like I said, Judge, we don't anticipate there to be any contested pretrial matters. In fact, I was a little bit surprised to see Mr. Elmore here. So I'm just going to ask court for a quick-ish reset. I know Mr. Craddock articulated to your honor that all of the pressure that I was under at the beginning of February is now at the beginning of March. And so however we can move that around and not interfere with the court's business, we would greatly appreciate.
Is this not a case where I've signed an agreed order on bail?
I think you did, Judge, but it was just for a PR, and now there's some sort of hold that we need to investigate. So maybe we either need to resolve this case on a more expedited basis or get a bond reduction as opposed to whatever we did before. I got it.
Mr. Woodward, is this the case where we were talking about duplicates? Is this a different case?
This is a different case, Your Honor. It appears in December, we had an agreed bond that set the bond. I'm unaware of any other holds. I'm taking a look right now.
Judge, I'm looking in the jail system and I don't see any additional holds beyond this burglary of a building charge. I will call book in and make sure that gets expedited. It's possible they didn't get sent a copy of the court's order. We'll make sure that they have a copy.
Well, let me ask. So the only thing that I show is a bail reduction in December, like Mr. Woodward referenced to $20,000. It doesn't say that it's a VR. It says it's, I'm gonna show you. This is what it says. So it's probably being held because Mr. Elmore hasn't posted the $20,000 bond yet. Is this what you're referencing, Mr. Ashman?
I believe so, Judge.
So if that's supposed to be a PR or something, then y'all need to send that in.
We'll get that fixed, Judge.
Read it signed.
We're also aware from Mr. Elmore that he believes there may be some other parole hold or some other hold that we can't see on our end. That's the holdup.
Yeah, potentially. I don't know. I haven't investigated that. It sounds like Ms. Heisel's going to do that. But from where I'm sitting, unless he's posted a $20,000 bond, that's why he's not being released from custody.
Okay, thanks, Judge. Thank you for clarifying.
All right, so let's set this. If there's no contested pretrial motions, we'll go ahead and set this for docket call. And I believe Mr. Ashworth, Mr. Craddock, we were setting you earlier today for April 12th. Any opposition to that?
No, Judge, thank you.
All right, we'll set Mr. Elmore then for April 12th. Mr. Elmore, if you do get out of jail, then your hearings will be at 9 o'clock in the morning here at the courthouse. If you don't get out of jail, then I will come to you via Zoom out there.
I'm worried.
Agree on anyone else, Mr. Ashby?
Yeah, Judge, yes, Judge, Rebecca Thomas.
Ms. Thomas, if you'll come forward. CR 18-452 on a motion to revoke.
Judge, we're here on this motion to revoke. I have been provided today the state's motion and amended motion. I've gone over them briefly with Ms. Rebecca. We're just asking the court for a reset, maybe to the next available contested. So that way I'll have an opportunity to work with the state of Texas to see if any agreements can be reached short of any final need for a hearing on this.
Okay, court will set Ms. Thomas for the contested docket on March 31st. If no agreements reached by that date, then we'll just have a contested hearing.
Judge, we're also ready on Ms. Vasquez.
Ms. Vasquez, Liliana, CR 15-46, also on motion to revoke.
Yes, Judge. Almost identical request. I've gone over. Today I've received the state's motion to adjudicate and revoke community supervision. I haven't had an opportunity to discuss with the state what agreements we can reach, if any. I'm confident we will. I'm asking the court for a reset, same thing, March 31st on the contested. So that way I'll have an opportunity to work with Ms. Heisel and Mr. Woodwike on a resolution.
All right, court will set Ms. Vasquez then for motion to revoke on March 31st. That'll be at 1:30. It will be here in the courthouse. All contested hearings, if we have one, will be here at the courthouse.
See you, I'll be in touch.
Okay.
Hang on, this is yours. Judge, I need just a moment, please.
Yes, sir. Mr. Landverdi, you'll step in front of that podium there. Yes. All right. All right, Mr. Landverdi. A second. Pull up your case. Mr. Landverdi, are you still on Circle Drive in Grand Saline? Are you still, is your address still on Circle Drive in Grand Saline? Okay. we'd sent out a notice that you're gonna have a hearing today on, at 9 AM.
But they said, but Boston said they had it down for these tickets and he didn't even get the notice. He had Mr. Bonnie.
Yeah, looks like it might have been sent to the wrong bondsman, but it was sent to you though. I'm not talking about your bondsman. We sent it to the bondsman and you. So you've got a motion to revoke that's been filed in your case where the state's alleging that you violated your community supervision. So are you going to hire an attorney to represent you?
Yes, sir. I will be able to March 1st.
So if I reset you to April,
Yes, sir.
who are you going to hire? Do you know? All right, Mr. Landoverdi, what I'll do is I'll set you. I'm going to set you for April 12th. I'll tell you what, I may set you earlier. Just a second here. Let me see if Mr. White's going to be back at a certain time. All right, I'll tell you what I'm going to do. I'm going to set you on March 10th. So that still gives you enough time. It's up to March 1st. Okay. All right, the deputy's going to bring this to you. You're going to sign here where it says defendant, and we'll give you a copy of it. And it's got your reset date on it, okay? Thank you. And that'll be at 9 AM. Oh, and Mr. Landoverdi, after you sign that notice, I want you to go with Mr. Waddell. And I want you to give him your analysis today. And then you're not free to go until he reports back to me, okay? All right, Mr. Butler, this is CR 15-9. You are Christopher Stephen Butler, right?
Yes, yes, sir.
All right, Mr. Butler, the state has filed a motion to revoke your community supervision. And it looks like you are under indictment for a manufacture delivery of a controlled substance, first degree felony. You intend to hire an attorney to represent you. Have you requested a court appointed attorney? What's your plan?
I mean, I'm okay with court appointed attorney. I mean, I shouldn't have any new charges, Your Honor. It was,
But let's don't talk about any of the allegations because you're not represented at this time. The state's attorneys are here, so it's best that you not say anything that could potentially be used to incriminate you or do anything that the state could use against you. Okay, so right now, all I really want to know is if you believe that you're indigent and you are financially to the level of being poor or poverty to where you're entitled to a court appointed attorney. Have you requested one? And if you don't believe that you qualify for a court appointed attorney, are you going to hire an attorney to represent you? So I kind of need to know what your plan is on what you're going to do with an attorney. Say again.
I'm indigent.
You're indigent. Okay. So have you filled out a request for a court appointed lawyer?
No, sir, I haven't. I didn't know I was being charged with anything.
Okay. How long have you been in jail?
About 6 weeks, 6 or 7 weeks now, sir. And
So
I was under the impression it was a motion to revoke, and that was it.
well, you understand a motion to revoke is a new charge. It's an allegation of violations to community supervision and that the state's seeking to have a hearing to revoke you and sentence you on the original charge. So, all right, go have a seat and Ms. Taberham will come and give you the paperwork. You'll fill that out and she'll get that information to me and I'll call you back up here shortly, okay?
Yes, sir. Thank you.
No, I don't have it, so we're gonna have to get it from the judge, so let's just go. Okay. You're right. Yeah, I'm it. Teresa. Judge, we're ready when you are.
All right, this is CR 21-224, State versus Teresa Jean Lopian, and Ms. Lopian is set for pretrial.
Judge, we don't believe we're gonna have any contested. We don't have any, and we don't believe we're going to have any. I'm asking the court to reset us for a docket call. Will allow the state of Texas and I to work on resolution of this matter. There's some things that Ms. Lopian has brought to my attention that I need to visit with Ms. Heisel and Mr. Woodwike about, but I think we're very close to reaching a resolution on this matter. We just asked this to be reset. Again, I know the court's given me some grace because of these special trial settings that have all been moved to March, so I'd appreciate it if the court could accommodate that request again.
All right, court will set Ms. Lopian for a docket call on April 12th.
Judge, we're ready on Casey Spriggs. Casey, come on in.
All right, Mr. Spriggs.
Oh, Manis. Judge, we need to do a check-in on Manis, and I don't want to forget, so I'm raising that flag.
Okay. This is CR 21-371, State versus Casey Lynn Spriggs. And I show Special arraignment and pretrial.
Yeah, we have some pretrial motions before the court. I've visited with the state about them. You know, they're essentially motions for further information. My understanding is from Ms. Curry that that information hasn't been available yet. The indictment is actually not shared with me on the portal system. So I'd ask the court to enlarge that if it were, so we can do the arraignment, which we are ready to proceed on right now. Casey, that's your name spelled correctly there. You see that? C-A-S-E-Y, Lynn Spriggs. And then down there, Casey Lynn Spriggs. See that? And you understand this is a first degree felony. We've talked about that with a 5 to 99 punishment range or life, right? We've talked about that. Yes, sir. And you've authorized me to enter a plea of not guilty and negotiate with the state of Texas on this charge. Yes, sir. That's. Thank you, Judge.
All right, so Mr. Spriggs' name is spelled correctly?
It is, yes, Your Honor.
And he waives the formal reading of the indictment.
He does, Your Honor.
And he enters a plea of not guilty.
He does, Your Honor.
Court will find that Mr. Spriggs has been arraigned on this charge of murder. And what were some of the, so you said there are some pretrial motions that will need hearings, or are they pretrial motions requesting discovery that's not been provided yet? They are pretrial motion. I don't believe that we're going to need a hearing, and I'd ask the court either let's set them on a contested. I don't believe that they're going to be contested. These are requests for information. The state's been very forthcoming about all the information that they do have. We've been provided a great deal of discovery. There's other things that we have requested, like medical examiner, some other analysis, what have you. That's not available to the state yet, as I understand it. And I believe it'll be forthcoming once the state has it. But my last request, which was only a few weeks ago, it was not yet available. But Ms. Curry and I have had several conversations about this matter to get the discovery request going. So I don't think we need to tie the court up at this time. I'd ask maybe for one additional pretrial hearing if we need it. Also, Judge, I think the court has approved a motion for funds for an investigator. And I believe we also filed, but we are not urging at this moment, some funds possibly for an appellate attorney if this case does in fact proceed to a trial posture, simply to protect the appellate record. And my recommendation would be somebody on this court's wheel or my colleague Jason Niehaus out of Denton County, Texas, who is an appellate criminal defense attorney. We'll take up that motion as we get closer to trial.
Yeah, I think it's premature at this time, Judge. I appreciate that. I just wanted it to be noted.
All right, we'll set this for an additional pretrial on April 12th. And we'll circle back to any information that you're still waiting from the state. And then once we get all of the information provided that you've requested, then we'll move past pretrial. So I'll reset pretrial to April 12th.
Thank you, Judge.
Judge, also for the court's information, and Mr. Ashmore, the indictment was not shared. It just didn't have the button clicked. It's been clicked now. Mr. Ashmore should have everything. Mr. Ashmore, if there's anything else that you believe you should have and don't, based on your discussions with myself or Ms. Curry, let me know and we'll be sure to get you whatever we've got.
Thank you very much. And Judge, we had a check-in on Alex Manis today. And that's matter number CR 21-00082. The court probably remembers that Mr. Manis is awaiting a bed at a mental health facility. Today was not a good day for Alex. I understand that from the staff here, he has good days and bad days. Today was just a bad day. But he's clearly being fed. He's safe. He's healthy. He's, of course, urging some release, but it's evident by his behavior here in this facility that he still needs mental health care. So I just urged him to remain patient, and we'll continue to check on him, and hopefully that space will become available sooner rather than later.
Okay, so you're waiving your client's appearance today at the status hearing?
Yes, Judge, I think it'd actually be a bad idea to try to take him out of his house.
Right.
He clearly doesn't want any interaction from the staff here, even if they are just trying to care for him. And that kind of goes double for me, so.
All right, we'll reset him for an additional status on April 12th.
Yes, Judge.
And I had a note, Ms. Taberham had indicated that on January 11th, he was number 144 on the Terrell State Hospital list. So hopefully he's moved up on that. If you need any updates on that, then you can contact Ms. Taberham or you contact Terrell State Hospital. I'm sure they'll tell you. But just to let you know, we are in the, Ms. Taberham and I are actively working on trying to get a contract with the Andrews Center to come in and hopefully on these individuals who have been deemed incompetent to go ahead and begin a regimen of medications that will hopefully get them on the road to restoration prior to getting into the Terrell State Hospital. So hopefully we can get that going here in the next 30, 45 days, and it'll benefit people like your client.
Thank you very much.
Who are diagnosed with mental illness and are on no type of medication and waiting for a system that's doesn't have enough places for it.
Yeah, that's a relief to know that there's that resource available. I know it's helped another client of mine I think it would help Mr. Manis, who clearly needs some help. Thanks, Judge. I think that's all for me. May I be excused?
Yes, and I believe Mr. Cannon is over here at the courthouse. So if you
okay. I'll be right down. I saw Miss Taberham here, so I didn't know if this was the principal's office or I need to go to the principal's. So I'll be up there.
That's the assistant principal's office.
Right. Thanks, Judge. Right. Hold on. Let me Casey.
Do we have Mr. Barry? Is he available in the courtroom?
He's being brought into the courtroom.
Okay.
Yes, sir. He's on his way.
And counsel, did you have enough time to talk with Mr. Barry about the plea papers?
Judge, when I went to the breakout room, nobody was in there but me.
Oh, okay. So,
I just need about 5 with him.
okay. So, Ms. Abraham, do we know where we're going to set him up? He's got to be outside of that room.
We were not able to hook up the computer to the internet. I called IT. We were not able to complete that. So
Good.
they're due out here now. So
Just use this room right here. So I'll I'll put the jail counsel in the breakout room, and then y'all will just come back. I believe we've handled everyone else except for the extradition, correct?
right.
And
So
Judge, I'll be fast. He's already been through the paper before. He knows the routine. We'll be real fast. Okay.
And do we know on Scott Gaines, was that an agreed writ, or are we going to be having a writ hearing on that with Mr. Ashmore?
that's the one who signed that they agreed. The state agreed.
Okay, so I've already signed out. Okay. So other than Mr. Barry, I think that takes care of everyone else in the jail. So, okay. So I'll move y'all over to a breakout room and y'all talk about that. Oh, I do need to see Katie Lynn Wiggins to show that
She was the one that was subpoenaed to Henderson County. So we're going to reset her and I'll appoint her an attorney.
okay. So can we just put her in March, a couple weeks? Maybe I'll put her on March 10th. Okay. All right. That's great. All right, both of y'all should have received invitations for room 1. If you haven't, let me know.
Your Honor, the jail has not received an invitation.
All right, so these rooms are not, let's try, how about now?
Yes, sir. Your Honor, Judge Martin.
Give him just 1 minute and he'll be with you, okay?
Oh, that's the least I could do. Y'all had to deal with me for 2 weeks.
All right, are we ready on Mr. Berry?
We are, Your Honor.
All right, Mr. Berry, sir, if you'll raise your right hand, I'm gonna place you under oath. Mr. Berry, do you swear that the testimony you give to the court will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you put your hand down. Make sure you speak up a little bit louder for me so that I can be sure that I hear you, and so my court reporter can take down what you have to say, okay? Okay. All right, your name is Grayson Tyler Berry, is that right?
Yes, sir.
And Mr. Berry, are you a United States citizen?
Yes, sir.
Do you read, write, and speak English?
Yes, sir.
Have you ever been diagnosed with any type of mental condition?
No.
In this case, you are represented by your attorney. Is it LeGrappe or LeGrappe? I can't remember.
LeGrappe.
LeGrappe. And you're represented by Mr. John LeGrappe. Are you pleased with his representation of you?
Yes, sir.
You feel like you've had enough time to review this case with Mr. LeGrappe and have all of your legal questions answered?
Yes, sir.
Is there anything about this paperwork that you've read over and signed and had Mr. LeGrappe review with you that you do not understand?
No, sir.
And Mr. LeGrappe, do you believe Mr. Berry to be competent today?
I do.
And you've explained to him all of this legal paperwork in addition to his legal rights, is that right?
I did, Your Honor.
And you believe he understands everything that he's read and signed today and the rights as they apply to him?
I do, Your Honor.
All right, Mr. Berry, you are charged by indictment with a third-degree felony offense of possession of a controlled substance in penalty group 1 greater than or equal to 1 gram but less than 4 grams. A third-degree felony in the state of Texas carries a range of punishment of not less than 2 years or more than 10 years confinement in the Texas Department of Criminal Justice Institutional Division, and also carries an optional fine not to exceed $10,000. Do you understand that range of punishment?
Yes, sir.
That means any sentence or plea bargain that's reached in this case has to legally fit within that range of punishment. I see here that the plea agreement in your case is that you would plead guilty to that charge in exchange for the state's recommendation that you be sentenced to 4 years confinement in the Texas Department of Criminal Justice, and that you pay a $1,000 fine plus court costs, restitution, and reimbursement fees, and that you would also be awarded 196 days credit towards your sentence for the time that you spent in jail on this cause. Is that your understanding of the plea agreement, Mr. Berry?
Yes, Your Honor.
All right. Mr. Berry, then, understanding the full range of punishment in the plea agreement, at this time, I'm going to ask you, how do you plead to possession of a controlled substance in penalty group 1 greater than or equal to 1 gram but less than 4 grams?
Guilty.
Are you pleading guilty, Mr. Berry, because you are guilty of committing that crime and for no other reason?
Yes, sir.
Has anyone threatened, forced, or pressured you to plead guilty today?
No, Your Honor.
All right, the court will accept the defendant's plea of guilt at this time. Mr. LeGrappe, any objection to the state's evidence?
No objection, Your Honor.
All right, state's evidence is admitted and the court takes judicial notice of the defendant's judicial confession. Is there anything further from the state?
No, Your Honor, we would rest and close at this time.
Anything further from the defense?
No, Your Honor, we rest and close at this time.
All right, court will review the evidence briefly. All right, the court has reviewed the evidence. I do find that there is sufficient evidence to convict Mr. Berry. Court will follow the plea agreement in this case. The court hereby convicts him of the third-degree felony offense in possession of a controlled substance in penalty group 1 greater than or equal to 1 gram but less than 4 grams. Court assesses his punishment at 4 years confinement in the Texas Department of Criminal Justice Institutional Division. Orders him to pay a $1,000 fine, $180 restitution, $290 court costs, and $70 reimbursement fees. The court awards Mr. Berry 196 days credit towards his sentence for the time that he has spent in jail on this cause. Mr. Berry, you're hereby remanded to the custody of the Van Zandt County Sheriff so he can carry out the terms and conditions of the sentence and have you step over with the deputy to be fingerprinted. Once you get out of TDC, it's going to be important that you contact the Van Zandt County Courthouse to make arrangements to discharge your fines, court costs, and fees. Failure to do so will result in a warrant being issued for your arrest. Do you understand? All right. Thank you, Mr. Berry. Anything further, Mr. LeGrappe?
No, much obliged for today, Your Honor. I really appreciate it. Much obliged. Thank you.
You're very welcome. Have a good day, sir.
Your Honor,
Yes. Yes.
Mr. Butler has completed his affidavit of indigency. We want to reset him.
Have you reviewed that?
Yes, sir. He will qualify, so we'll need to appoint.
All right, let's reset him. Let's see, we'll set him on March 31st, which will be the contested docket. And Ms. Tabraham, when you send that notice, if you'll make sure that the attorney that receives the notice understands that that is the contested date. And then we're making the appointment more than 30 days out.
Yeah, I think all we have left, Judge, is the extradition.
Okay,
Judge, may the state be excused?
we got Mr. Cannon still here in the courtroom if you want to stick around for that.
Oh, got it.
Okay, so Jill, if you'll just turn off the camera and mute yourself, and I'll come back on for the extradition once I conclude with Mr. Ashmore and Mr. Cannon.
Yes, sir.
Mr. Landoverdi. All right, Mr. Landoverdi, if you'll step back up to the podium. All right, this is cause number CR 12169. All right, Mr. Landoverdi, I believe I've already set you for March 10th, right? And Mr. Waddell indicates to me that you provided a sample and that you are negative. So you are free to go. We'll see you on March 10th with Mr. White.
Thank you. Sir, do I want to see my probation officer?
The probation officers are over at the jail right now. Who's your probation officer? If it's not Rachel Matura or Karen Burns, then yeah, you can go see your probation officer. Mr. Ashmore, are you ready up, Mr. Cannon? All right, Mr. Cannon, if you'll step up. This is cause number CR 21282, State versus Justin Lee Cannon. We're set for docket call today.
Mr. Cannon was delayed getting here today. Last round of negotiations I had with the state of Texas, they're doing some additional investigation with their complaining witness, who is my client's brother. And we're awaiting any final plea negotiation based on their interaction with their witness. We're trying to stay away from him. We don't want to raise any specter because of the close familial relationship. And we've told the state's office about what we understand the facts to be. And we just need them to confirm with the victim so we can finalize whatever resolution there may be for coming and explore any plea. I don't know where they are with that. I don't know if they've had time to do that. I know everybody's had a busy couple of weeks.
State, were you able to hear Mr. Ashmore?
Yes, Your Honor. And Mr. Ashmore did provide us with that at the last setting. We have been unable at this point to locate that necessary witness. So we would ask for a short reset to allow our victim services person and perhaps even our investigator to get involved to help track down that victim for us.
Judge would propose and ask for a reset for maybe an additional docket call.
All right, court's going to set Mr. Cannon for an additional docket call on April 12th. That will be at 9 a.m. if Mr. Cannon is on bail, 1:30 if he's in jail.
has a CR 14, but this is a CR 20 number, isn't it? Or 21?
I got CR 21-282, Justin Lee Cannon, aggravated assault deadly weapon from August 27 of 21. I've got a notice of setting up here if you need it, if you could use it. So what was the confusion? You got a different cause number?
On his findings, there's CR 14.
Well, yeah, that's the delinquent on that case number CR 14474. So there's a docket showing me that he's not keeping up with his payments on his past cases. So that's stuff I take into consideration on conditions of pretrial release, whether or not somebody should be granted probation, things of that nature. Mr. Kane, the only other matter that we have before us is your drug test today. All right, I asked that you be drug tested. Mr. Waddell, if you'll come around here. Mr. Waddell, I asked you to administer a drug test to Mr. Cannon. Did you do so?
Yes, sir.
And what was the result of that?
The results were positive for methamphetamine.
Positive for methamphetamine.
Yes, sir.
Are you going to send that off for confirmation?
Yes, sir.
All right, Mr. Cannon, the court's going to find that you have violated the terms and conditions of your pretrial release. The court's going to find your bond to be insufficient at this time, and I'm going to take you into custody at this time.
So it's positive here, right? It's a DNA test here, it's positive. Lab confirms. It's gonna be sent off, it's false positive, we'll know.